started. First of all, some administrative issues, because I have gotten several questions. And if a couple of people have these questions, many of you probably have these questions. Question one, can you call more than, let me back up. Each one of you needs to do at least one cross, one direct, and either the opening or the closing. All right, everybody knows that. But then the question is, can you call more than one witness on direct? More than one witness, well, you don't control how many witnesses you cross. Can you call 4 witnesses on direct? Yeah, you can do that. That's fine. You can do whatever you want, as long as you kind of equally split up the time. That's all that matters, and you at least do one direct. Yeah.
So, but we can stipulate to the depositions for the witnesses we don't use.
Yeah, sure, but you know nobody's going to read the stipulations. I mean.
Well, I understand that, but
Yeah.
I mean, there's pertinent facts.
Yeah.
Calling for time, say judicial efficiency, right?
Yeah, that's all fine. Yeah. So that's question one. If you want to call, now you also, there are witnesses assigned to your teams. Those witnesses can play all the roles, or they could play, 2 roles, and then you and your co-counsel can play witnesses too. All right? So you don't have to get you have to give some work to the witnesses who are assigned to your case, but you don't have to give them all the work. You all can be witnesses for each other. All right, any questions about that? Yes?
Are you gonna print out any of these things, or PDF, or we have to reinvent the wheel for exhibits?
What do you mean?
Oh, yeah,
Are we going to
people
print
been
out our
asking
book all over again?
about demonstratives, so people have said something about blowing up the map for demonstrative purposes.
I mean, if you want to do that, you can, or you can use, hopefully, we're going to have PowerPoints in the rooms, but like I tell people all the time, when you go to court, you never know whether the PowerPoint's going to work. So you need to be prepared to go without a hiccup if there is no PowerPoint in the room or it's broken. I don't understand the reinvent the wheel question.
Well, I mean, I didn't download the electronic book, I purchased the paper book.
Okay.
If I had to use exhibits to be like, have you seen this before? Do you recognize this? Is this familiar?
Yep.
I mean, am I just gonna use my book?
No, because remember, you need 3 copies.
Okay, so are you guys gonna PDF the book for us, or we have to copy the book ourselves?
I've got a PDF of the book. If you send me an email to remind me, I will send the PDFs to Delaney and Shanice, and they can post it on the website.
Thank you.
Yes. But also, well, that's the easiest way. That is the easiest way to do it. You could also, scan it with Dropbox on your phone and then just print them out.
Yeah.
But it's easier to do what you proposed, and that's what we'll do. Other questions? Can't think of any other questions that I've gotten from other people other than those. But keep them coming, and we'll keep answering them. All right, no other questions? Okay, well, what we're going to talk about now is a topic that I guess thankfully you're not going to have to do for your trials, but you are going to do on Monday for purposes of just going through the experience once. And I've got and so does Professor Lassen. We both have kind of mixed feelings about talking about jury selection, because jury trials really are few and far between. I had a lot of them when I was doing criminal work. I had one a couple of weeks ago, oddly enough, in a fee dispute between lawyers in Baton Rouge. But almost all the work that I do is a trial or oral arguments, the trial before judges or hearing panels, oral arguments before appellate panels, and you just increasingly see fewer and fewer jury trials. So that's why we are a little reluctant to spend much time on jury selection. But this is the time to think about, from an academic standpoint, all sorts of things that maybe in real life you won't encounter right away. Some of you might go off and be DAs or public defenders and will be doing jury trials in the first couple of months of being a lawyer. So again, it's with some hesitation that we are spending a lecture and a performance on jury trials, but let's do it, because some of you may really be doing jury trials, and it's just an important skill to think about. And the paradigm here is that we try cases before juries. so you should know something about jury selection. Okay. Some of the preliminary matters involved with selecting a jury. These people are unhappy. And I really almost forgot that before we picked this jury up in Baton Rouge a couple of weeks ago. They didn't want to be there. And an old crusty journalist from the 50s, H.L. Mencken, said, "A jury is a group of 12 people who, having lied to the judge about their hearing, health, and business engagements, have failed to fool him." And man, I watched all sorts of people with all sorts of really bad excuses trying to get off of the jury. So they're not happy. A couple years ago, a friend of mine sent me this, which was a guy who submitted an affidavit trying to get out of jury selection. And he says, "Apparently your morons don't understand me the first time. I cannot take time off work. I'm not putting my family's well-being at stake to participate in this crap. I don't believe in our justice system. And I don't want to have a goddamn thing to do with it. Jury duty is as complete waste of a time. I would rather count the wrinkles on my dog's balls than sit on a jury. Get it through your thick skulls. Leave me the fuck alone." That guy didn't want to serve on a jury. Now, most jurors aren't that graphic and adamant, but get the point. They're not happy. Well, you really need to know the law, the mechanics and customs of jury selection. Like, for example, you need to know how many strikes, peremptory strikes you get. Is it 6? Is it 12? What are the customs? How does the judge allow you to do it? Does he allow back strikes? Does he ask the plaintiff first and then the defendant, and then does he swap it around and start with the defendant? And some of this is not written down in any book. It's just the way they do it in the courthouse, or the way they do it before this judge. So you need to know the basic law that's set forth in the Code of Criminal Procedure or the Code of Civil Procedure. You need to then look at the local rules and see if the local rules say anything about the way jury selection's done. And then you really need to either go with the lawyer who's tried a case, a jury case before this judge, or stop by the judge's chambers or call the clerk and say, "Hey, you mind telling me how the judge does jury selection?" That's what I did. I didn't even know this judge. I just called the clerk and I said, hey, look, I'm a lawyer from New Orleans. I haven't been before Judge so-and-so. Can you tell me exactly how he's gonna pick the jury? So don't ever be afraid to call and plead ignorance when it's true ignorance, and figure out the way the judge does it. How many people is the judge gonna put in the box? Is he gonna put 12? Does he wanna pick an alternate? These are all sorts of things that you just need to think about in advance. All right. What is the purpose of jury selection? Well, of course, the purpose is to select jurors. After all, it's called jury selection. So that's part of it, obviously. But you also want the jurors to select you and your case. That's a huge part of it, because this is the first time that you're gonna get to stand up and tell the jurors anything about you and anything about your case. Now, you can't do a lot of this, but it's the first chance, so this is where you need to start selling your case. All right. So given those preliminaries and the purposes of jury selection, let's talk a little bit about the style of jury selection. And thinking about kind of how you carry yourself, what you want to portray about yourself and about your case. Well, obviously you're gonna stand up. I mean, some places want you to sit down to do a lot of the court proceedings, but most places you'll stand up. At this trial that I had, the judge got angry every time the lawyers got out from behind the podium. He didn't even want to see this. So you got to figure out exactly where you stand. Now, this says stand and approach the jurors. This judge wouldn't have allowed that last week, or a couple of weeks ago. But if you can, it is good to go up to the jurors, but don't intrude. If you go too close, you get in their collective personal space, and we all know there's nothing more irritating irritating than somebody getting a little too close to us while they're trying to talk to us. Don't be that person. And if you are gonna step forward, just do it in a non-offensive, annoying kind of way. It's a long way of saying, don't be annoying. And it's good advice all the time, I guess, not just with jury selection. Be friendly, professional, and competent. Again, nobody likes a jerk. This is the first time these unhappy people are seeing you. And you know, we all form impressions about people right away. We don't wait and say, hey, I'm gonna give this person a chance. I'm gonna see what this, we immediately start saying, oh, this person's wearing khakis and has got his button undone. He must be kind of casual. I mean, they're gonna start thinking those things right away. And so you've gotta be friendly, you've gotta be professional and competent. Professional and competent. Ethos. Remember, I don't think I've stood up before you to give a trial ad lecture all semester without ethos coming out of my mouth. Remember, personal advocacy, rule 1, it's the most important thing is what the jurors think of you. So what do you want them to think of you? Well, that you're competent, that you're not gonna waste their time, that you're professional and you respect the authority of the judge and your opposing counsel. Most of all, they don't want their time wasted. So go through the jury selection process as quickly as you can. Okay. Be conversational and non-lawyerly. This is the time, again, you want them to understand that you're a professional and competent lawyer, but you also want them to understand that you're a human being. Show that you, some sympathy, empathy for their situation, that they are stuck there and they would rather be somewhere else. Be conversational. After all, this is the only time where you are gonna get to talk to the jurors and have them talk back and answer your questions. So be conversational. Don't turn the whole thing into a lecture to them, and don't be talked down to them. And that's what I mean by non-lawyerly. You want to be a human, but you don't want to act like they are below you. Actually, they are far more important than you at this trial because they're going to decide your client's fate. Reveal something about yourself, maybe a fear. We like people more when they stand before you and they reveal some vulnerability. It makes them more human. So, I really think, and this is what I've done in all my cases, I did it in this case, is you reveal a fear about your case. In my case, my clients they were a law firm, Dudley DeBosier. Everybody's heard of Dudley DeBosier. So what is my concern when I'm there? It was that they hate advertising lawyers. So when I stood up, I was like, ladies and gentlemen, I represent Dudley DeBosier. There's Mr. Dudley, there's Mr. DeBosier. You may have seen them on TV. Everybody laughs. And I said, I like these guys, but a lot of people hate them because they're on billboards. My biggest fear is that their claims in this case are going to be handled by jurors who hate advertising lawyers. And I respect that. I don't like some of them myself. So what I need to know from all of you all is, I need to know if you are going to hold against Chad, Dudley, and Steve DeBosier the fact that they advertise. And if so, we respect that. You'll get to go home. But we need to know. Well, you know, then we had a conversation. Sir, let's go ahead. Sir, what's your name?
Robert.
What do you think about advertising lawyers?
I think their commercials are funny.
Kind of silly sometimes? Do you think that it's okay for lawyers to advertise?
Yeah.
Yeah, I mean, you've seen advertisements from Our Lady of the Lake Hospital and from Auctioner Hospital. Doctors advertise all the time, and you don't hold that against them?
Mm-mm.
These guys advertise because they want to get their name out in the community, and they've been quite successful at it in representing their clients. So you wouldn't hold that against them?
No.
Ma'am, what's your name?
Caroline?
Caroline, you already heard my questions. I don't want to waste everybody's time. Would you hold it against Chad Dudley and Steve DeBosia that they advertise on TV and on billboards?
Maybe.
Why is that?
It depends on what the claim would be, honestly, and it would just depend on what they were arguing for. I wouldn't feel sympathetic in terms of money as much as I would for somebody else.
Now, you see, I would probe that some more, and in probing it, I'd be arguing my case. Like, I would get you to say, you're not gonna vote for or against them because they're on TV, but based on the merits of their claim. And they don't want, all they want is a fair trial. So we'd go through all that, and I would have the dialogue, and would eventually, and you see what I'm doing is I'm arguing my case. I'm arguing, all I want is a fair trial. I really want to win, but I want my ethos, right? I want to appear to be the guy who wants the fair trial. So that's what we do. So again, my fear in that case that I revealed to the jury is that they were advertising lawyers and they would get that held against them. So. All right, let's talk about selecting jurors. Well, and not only selecting jurors, but selecting jurors. First of all, this bothered me the first couple of times I tried a jury case. The judge gets all the jurors in the box, and you're trying to scramble and write down their name, and who's who? Is that Ms. Jones? Is that Mr. Franks? Is that Mr. Smith? And you have to write their names down. So you need something like a chart, and you can download these on the internet. A chart so you can write people's names down. I actually did it on my iPad, and there's a little iPad chart that you can buy, and you can write people's names on it. You just need to be ready to do that. Now, some lawyers, and I did this for one trial, some lawyers get all those jurors in the box, and they memorize all their names, and like where they, because all you know from the list of all the potential jurors is what their names are, and what they do, like teacher, oil or refinery worker, and they just list name, and also where they live, the neighborhood, the city they come from. So I remember being in trial with one lawyer, and he'd memorize everybody's name. So you would stand up. Ms. Smith, my name is Dane Ciolino, and I know that you work at the Chevron oil refinery, that you live on Smith Street, and I've got a couple of questions from you. Wait a second. Oh, Ms. Jones. And he knew everybody's names. And at first I was like, damn, that's good. And then it started looking creepy. So I've got mixed feelings about this. If a lawyer is not looking at any notes and he knows where you live and where you work and what your full name is, that's a little creepy. So you gotta write their names down. I think it looks a little better when you just go, Ms. Smith? Yeah, yes, okay. Now, I understand, staying from the clerk sheet, that you work at the oil refinery and that you live in Marrero, right?
Yes.
Yeah, well, let me, you've already heard some of my questions to the other jurors. I don't want to, again, waste all of our time, but let me follow up on a couple of questions with you. So, there it is. I think that's a little less creepy. That's just my style. Now, if you can pull it off, if you can memorize all these names, rank serial numbers, locations, occupations, good for you, but just don't be too creepy about it. All right. Now, who are you selecting? You hear all kinds of stuff about what kind of jurors you want for this kind of case, and what kind of jurors do you want for that kind of case. And a lot of it, well, I mean, Clarence Darrow, we all have heard of Clarence Darrow, a famous lawyer, did the Scopes trial in the 30s or 20s or whenever that was. But in his book, I mean, this is cringeworthy today in 2019, but in his book, here are some of the things that he said. I mean, this was his legitimate book on jury selection. He said, you know, an Irishman, put him in the box, he's emotional, kindly and sympathetic. You'd be guilty of malpractice to get rid of him if you're the plaintiff. You want him. But Presbyterians, man, get rid of those Presbyterians. Baptists are hopeless. The sooner they leave, the better. You don't ever want a Scotchman. for he has too little human feelings. I don't want a Scandinavian, for he has too strong a respect for the law as law. Now, what the hell were these kind of stereotypes, you know? I don't, maybe they worked better in the 20s or 30s when he was practicing, but, I mean, these kind of, but do lawyers use other stereotypes? And do lawyers in picking jurors? Well, this is the most common rule of thumb for jury selection. And frankly, I think it's, I kind of agree with it. In jury selection, you want a jury that looks like your client. So if I've got if it's a sexual harassment case and I'm representing a woman against a company, I would prefer to have a lot of women who worked at big companies that are about the same age as my client. Why? Because they'll identify with her. They've probably gone through the same crap that she has. If I'm representing a defendant in criminal district court on Tulane and Broad, I would like a jury full of African Americans between 18 and 26 years old, because that's what most of the defendants at Tulane and Broad look like. They are certainly going to give my client a fairer shake than a bunch of people who look like the police officers. If I'm representing a client charged with rape, I'd rather more men on the jury about his age. Now, doesn't that make me sound racist and sexist? Sure does. But that's kind of a rule of thumb that people use in jury selection. It sounds racist and sexist, and it sounds inappropriate, but does it happen every day in courthouses all over the United States? Yes, it does. Does that work? And is that the way you want to select juries in all cases? No. I've selected juries in capital cases in federal court in New Orleans. And in a capital case, my goal is to have one vote for life. It'd be nice to have more than one. But under the Federal Death Penalty Act, the FDPA, I only need one vote for life. And you know what? My client gets life. He doesn't get executed. So what am I doing when I'm picking a jury? Well, I'd love all the jurors to look like my client, but that's not going to happen in federal court in New Orleans. It's just not. We're drawing from St. Tammany Parish, Washington Parish, Livingston Parish. We're not going to get a jury that looks like my client. So what am I looking for? Well, I'm looking for people that are very different. I would like the older white man and the young black woman and the immigrant who speaks decent English, but not great. Why? Because these are all people who would never talk to each other out on the street. They might hate each other. Hopefully they hate each other when they get back into deliberations, because they aren't going to be able to pal around together and agree, maybe. So that's an odd selection process. In that particular kind of case, I'm looking for, I'm not looking for a homogeneous jury. I'm looking for whatever the opposite of homogeneous is. What's the opposite of homogeneous? What? Heterozygous? Does that have something to do with genes? Heterogeneous? Heterogeneous? Somebody Google it. I want a heterogeneous jury is what I want. I don't want any homogeneous juries like milk. I don't want that. I want homogeneous. So in any event, what's the point? You go through all of this trying to figure out jurors who are going to like you and your case. But at the end of the day, you know, you're probing predispositions, attitude, case-similar experience, and your biggest fears. So if I'm asking questions, I'm asking questions like, ma'am, have you ever been in a dispute over work that you've done? And this was in my case. My clients, Dudley DeBosier, had gotten fired from a case, and they had a fee claim. They're fighting over a $1.3 million fee with a successor lawyer. So our argument was that the other lawyer didn't want to pay him anything, though they had worked on the case for 4 years. So I'm asking people, have you ever, do you know any contractors? Oh, my brother's a contractor. if your brother works on a house for a couple of years, and he's got rain delays, and the owner is upset because the house isn't done, and fires your brother, you think your brother deserves to get paid for the work done before he was fired? What do you think?
Yes.
Why? Now, big open-ended question. I want her to make my argument. Go ahead. Why do you want your brother to get paid?
Because he put in the time and effort, and it's just not fair to not get paid.
Yeah, if the guy who comes in and works for a few weeks and just finishes up gets to keep all the money, that wouldn't be right, would it?
No.
Then I'd go to someone else and start asking the same kind of questions. And what am I doing? That's my case. That's my whole case, is that Dudley DeBosier worked on this case for 4 years, and they got fired. Did I already talk about this in another class? Do you know why they got fired? The lady told me in the deposition. Trial started on Monday. We took her deposition. The client who fired Dudley DeBosier said that she fired. I said, why did you fire Dudley DeBosier? Well, because Amber was the lawyer on the case for Dudley. Amber was working on the case. I said, well, you didn't get along with Amber? No, I didn't like Amber. Why? She says, because a man needed to try this case, not Amber. I said, why is that? She says, well, because like if you're really sick, you need a man doctor. If your case is going to go to trial, you need a man lawyer. And I'm just sitting there. I wanted to just jump up and down and hug the lady because it was great. I mean, how great is that? So, of course, in our jury selection, I wanted kind of working professional women who would hate this lady. And we got a jury full of women, all but like we got 12 jurors and an alternate. I think 9 of them were women, several professional women, and you know what the other side did? We settled. They didn't like that jury, so we settled. So, I would probe predispositions, ask you about hypotheticals that are very similar to my case, and predispositions like, are you predisposed against advertising lawyers? Those sorts of things. Exercise and oppose challenges for cause. This is really what you think jury selection is about, is weeding out the people who can't be fair. And in death penalty cases, for example, this game is all, for me as the defense lawyer, it's all about weeding out jurors who will not consider mitigating evidence. Under the law, if you're going to serve, and this is the way that I would put it to the jurors, under the law, and the judge is going to give you the law, but the judge is going to instruct you that you've got to consider mitigating evidence. Now, a lot of people don't think that they should consider mitigating evidence. They believe that if you've killed somebody, under the principle of eye for an eye, you deserve to die for what you've done. You're going to hear that this man killed someone. And what I need to know, and my fear is that people will be on this jury who will not be able to consider mitigating evidence. There are some people that say, I don't want to hear it, eye for an eye. There are other people who say, oh, his father beat him up. That's no excuse. So what I need to know is if any of you all are going to be that kind of jury. And I'm not faulting you for it, but if you can't hear mitigating evidence, you can't sit on this jury. So, ma'am, what's your name?
Stephanie.
You ever heard this thing called the abuse excuse?
No.
Some people say, oh, it's an excuse that people try to get off crimes just because their parents beat them, they had poor upbringing. Now, you've heard that before?
Right.
In this case, you're going to hear testimony that this man was beaten repeatedly by his father. We're not suggesting that he should be excused from responsibility because of what his dad did to him when he was 3. But I'm asking you whether you can consider it, not in letting him off, or letting him go free, but in weighing whether he should be put to death or whether he should go to jail for life. Can you consider that?
Yes, I would definitely consider that.
You see what I'm doing is I'm arguing my case. And I'm getting you to commit to me that you'll consider mitigating evidence. And believe me, me, I'll hit some people that go, look, I don't know, man, if he kills somebody, well, then you get that out. And then what happens then? Well, then I start saying, you couldn't follow the judge's instruction. I try to commit them to not following the law because I want to exercise a challenge for cause. Because challenges for cause are free to me. I've got as many of them as I want. So of course, the prosecutor wants to get, I'm just pointing to you, but the prosecutor, if you say, look, man, I'm not sure, and then you go, well, maybe I could. The prosecutor's going to stand up and rehabilitate you. He's going to say, well, sir, you would follow the law that's given to you by the judge, wouldn't you, sir? Would you follow the law?
Yeah.
If the judge tells you the law is you have to consider mitigating evidence, would you follow the law or would you just ignore the judge?
Follow the law.
You see the game, how it's played? Now I'd go up and try to strike you for cause. Judge, he's not going to consider mitigation. You heard him. And then the judge would say, well, he said he'd follow the law. And then I go, I'll exercise a peremptory, right? The judge, and this is the way the game goes, the judge wants you to waste your peremptories. Why? Because that's what slows the process down. As long as you got peremptories, then this is going to go on all day. If the judge denies the challenge for cause because you said you'd follow the law, and it works both ways, right? I'm looking for the automatic death jurors because there are a lot of them. You'd be surprised. You'd be surprised, the people out there. And I want them to say eye for an eye, and they're gone. All right. You also want to exercise your challenges, your peremptory challenges. And this is when the judge says no cause, the juror will follow the law, and then you know that this person is going to vote against you. You know it. And then you got 12 of them usually, and then you just strike them. So you got to beware Batson. Anybody know what Batson is? Batson is the Supreme Court case that says you cannot exercise peremptories on the basis of gender or race. So what does that mean? That means in most criminal cases, if the defendant is African American, the defendant's lawyer, me, I'm striking all the whites from the jury. The prosecutor, striking all the African Americans from the jury. Is that what's happening? Yes. Is that what they say? No. What do you have to do? You have to give race-neutral reasons. Your Honor, that juror was fidgeting and not paying attention. That's why I struck her. Yeah, that other juror, well, the jury just kind of was a little in her voice, just looked a little uncomfortable about being here, so I struck her. Now, does this sound racist? Does this sound sexist? Yes. Does this happen? Yes, every day. Now, don't go tell the dean's office I'm telling you to be a racist and sexist person. I'm just telling you what the world's like out there, right? The world's not perfect. Lawyers are exercising challenges for constitutionally improper purposes, and it is wrong. Everybody get that on their recorders? It's wrong. Wrong. Okay. But beware, Batson, because the last thing you want, and I've been accused of Batson violations. I've accused prosecutors of Batson violations, and when you're sitting there, you're looking at each other. Like, who's going to launch the first missile? Because, Your Honor, Batson, and everybody goes, oh, here we go. And then the other side says, yeah, well, they're Batsoning too. Here we go. Why does nobody really want the Batson missiles to come out of the silos? Because then you got to throw all the jurors out, and you have to start over again.
Oh, gosh.
It's a mess. But it makes sense. I mean, the law couldn't be otherwise. It violates equal protection. If you allow lawyers to be striking jurors because of the way they look, that's wrong. All right. So that's what jury selection's all about, is asking the questions, finding out who's going to be on your side and who's going to be on the other side. But do you really know? I mean, this is just an exercise in fortune telling, isn't it? You can figure it out sometimes pretty much who's gonna definitely be against you or definitely be for you. On my death penalty case, man, I'd love a social worker Democrat who looked like my client. My God, that would be great. And I know I don't want the NRA Republican old guy from Washington Parish, probably. Again, I'm just making this up, but my crystal ball is screaming at me for that guy to use a peremptory on him. But it's all just guessing. So this is an important part of jury selection, but I'm not sure it's the most important part. It works at the margins, but for the vast middle, I'm not sure that the crystal ball really works that well. So that's why I think you should really be really focusing not on picking the juries. And remember, it's not jury selection, it's really jury non-selection. You don't pick who you want, you just pick who you don't want. And then whoever's left is the jury. So it's really not jury selection, it's non-jury selection. And whoever's left is the jury. But it's really about having the jurors select you and your case. This is ethos again. You want them to start liking your case. So this is all about building the platform for your case. And you saw me doing it already. If a big theme in my death penalty case is this childhood abuse, then I'm sending those themes out during jury selection. And I'm getting you all to tell me that that's not bogus, that that's real. If a big theme of my case is that my clients did a lot of hard work and these other people are just trying to take the benefit of it, and that would be unfair, I'm platforming that theme, and I'm getting buy-in really from you, the jurors, potential jurors, that my basic principles you agree with. So that's really what platforming 101 is getting the major, and this takes a lot of thought. Before you go into that jury selection, you need to figure out what your biggest fear is about your case and what your one or two strongest arguments are. And you need to go out there strong with those and build this notion that your view on those you better make sure that your hypotheticals that you're committing the jurors to are going to be borne out by the evidence. But that's what platforming really is all about. Building that platform for the case that you're going to build. One thing that you never ever do is talk about being a holdout juror. Now, and I've seen people do this, defense lawyers in death penalty cases. Now, if you feel really strongly that the defendant should be acquitted, but everybody else thinks he's guilty, would you stand strong in your convictions?
Yes.
Well, I mean, then what is everybody thinking? Wow, this guy must have a really shitty case where probably 11 people are going to vote against him, and he wants one person. I mean, that sounds desperate, doesn't it? So be careful talking about holdouts. And also, again, and I said this when we talked about opening, and this is even before opening. So really don't stand up and say, sir, do you understand that the prosecutor bears the burden of proof and the defendant cannot be convicted unless the prosecutor proves every element beyond a reasonable doubt. And if the prosecutor can't, well, he gets to go free. What does that sound like? Sounds like I'm worried about technicalities. I don't want to stand up and be sounding like some technicality spouting lawyer. I'm the guy who's interested in truth and a just result here. Not getting off because some evidentiary standard, whatever that is. If I'm talking about evidentiary standards, what am I? I'm a weasel. I'm a weasel. Don't be a weasel. It's cute. It's a cute weasel. But don't be a weasel. It's cute. Was anybody in my legal profession class today? I had weasels in my legal profession class today because we're talking about Rule 4.2. And I think I'm going to use this weasel from now on because he's a cuter weasel than because I saw the reaction that he was a cute weasel. My other weasels are really cartoon weasels and they're not as good as him. Okay. Make contracts with the jurors. Make contracts with the jurors in the sense saying, if the evidence shows that Mr. Smith's I'm just trying to think of a good situation where I did this. If after all the evidence is in, you firmly believe that Mr. Smith did not commit this crime, what would your vote be?
Not guilty.
Not guilty. Ma'am, what would your vote be? What would your vote be?
Not guilty.
Your vote?
Not guilty.
Your vote?
Not guilty.
Your vote?
Not guilty.
Doesn't sound good. Doesn't sound good. I want him to say not guilty. So then on closing, I could say, every one of you all assured me during jury selection that if the evidence did not establish that this man could rob this convenience store, that you would vote not guilty. You heard the evidence. Again, you just kind of make that contract and you go back to it and hold them to it. Those are just some thoughts, and you know what? Jury selection's fun. I don't know why I find it fun, but it's just fun because you can talk to the jurors, you can platform your case. I really like the platform in the case, and I really like to have somebody else kind of looking and doing the let's strike this one, let's strike that one part of the game. I like to do the advocacy part, but you got to do both. Get the ones that are really bad off of your case. Work hard to rehabilitate the ones that are really good on the other end of the margin for your case, so your opponent has to use those challenges for cause. But as to everybody else, the great middle who's going to wind up on your jury, platform your case. So this is what you all are going to be doing. This is the schedule and the plan for Monday, right? You're going to do jury selection. How's that going to work? You're going to stand up before everyone else in your class. They are all going to be the prospective jurors. The adjunct professors are going to be the judges, like usual. And you are going to select a jury for this case, the case that our casebook case. You're going to select a jury. And you need to think about, and this is where the preparation comes in. What are your greatest fears? What do you want to learn from the prospective jurors who may sit on this case for you? What are the biggest problems with your case? What are your central themes that you want to develop hypotheticals about and ask the jurors questions about? That's what you're going to do when you're on your feet. What is everybody else going to do? They are going to be the prospective jurors. So what you need to do is two things. You need to figure out how you're going to do the voir dire when you are the lawyer. And number two, you need to figure out who you are. Now, I know many of you have probably been doing this for a lifetime. But you need to figure out who you are by way of a juror. And you need to get in that role and play it. And this is hard to do. You know why? Because some people, go there and the jury start asking questions, and it turns out they've decided that they are a circus clown. And I mean, come on. Be something realistic. Work at a grocery store. Be a lawyer. Be an accountant. Be somebody who is realistic for New Orleans. Okay? Maybe you work at Rouse's as a cashier. Maybe you work as an accountant on Poydras Street. Maybe you are a licensed practical nurse at the medical center. I don't care what you are, but you need to be that person, and that person needs to be realistic and consistent in that role. And it's hard. This is where the jury selection simulation goes awry. Is that people come with absurd roles. They're trapeze artists. I mean, whatever. They come with absurd roles. Don't come with an absurd role. Come with a realistic role for New Orleans, greater New Orleans area. Okay. Then during the mock questioning, they start throwing out bizarre answers just for fun, because it's funny. And you know what? It's funny. It's funny. But we're not trying to be funny. We're trying to make this a realistic simulation. So, number one, have a realistic persona, character. Number two, when you're answering the question, stick to that character. Don't start laughing, and don't start throwing out stupid, silly answers. Now, you also may decide you're a person, there are people who just are trying to get out of jury selection. You may be one of those people. You may be a person who really wants to serve on a jury, maybe too bad, too much. There are those people too, those people are scary. Again, I'm not here to tell you what kind of character to be. I'm gonna leave that up to each one of you all individually to decide who you are when you're gonna be in character. But when it's time for you to be in that box and start selecting a jury, get in that character, be consistent with your answers, don't be silly, and we'll all have fun. It really is, it's one of the funner days. So that's the plan for Monday. We're picking a jury. In this case, you're gonna be a juror, and you're gonna be a lawyer. Now, you can pick one persona and live with it. For one person standing up, you could be an oil worker. For another person, you could be a nurse. It doesn't matter. You can go as many personas as you want, because remember, each person's gonna stand up for at least 5 minutes, maybe 7 minutes, 8 minutes. Each person is gonna get on their feet for 5, 6, 7 minutes and select and go through jury selection. Now, most of what you should be doing is platforming, all right? Maybe you can do a little bit of questions trying to weed out, do the witch hunting, get the witches off the jury, but mostly be platforming. All right, questions about our simulation on Monday? Okay, we'll see you Monday.